Here's a question we get sometimes. We'll have a client come to us and let us know they're married to a U.S. citizen, they have a lawful entry, but they also have a criminal history. How does the criminal history impact their ability to adjust status and get a green card in the United States? More on this after the break. Inadmissibility to the United States can be overcome through an immigration waiver. I've had to record this video a bunch of times because I keep tripping over the word inadmissibility. So if you hear me say it and just kind of flub it throughout this presentation, forgive me. We're going to talk about how you can waive inadmissibility. And again, remember this series of videos focuses on how, as an immediate family member of a U.S. citizen, you can adjust status in the United States. And so not all aspects of all immigration waivers are going to be covered in this video. This is not a comprehensive presentation. A couple of short things you need to know. Some grounds of inadmissibility are automatically waived for immediate relatives. And then for those things that aren't automatically waived, many times that immediate relative relationship will allow you to apply affirmatively for a waiver of a grounds of inadmissibility. There's that word, inadmissible. Okay, so let's talk about time-related grounds of inadmissibility. If you've been present unlawfully in the United States for 180 days, then a 3-year bar is automatically imposed, so you're inadmissible to the United States for a period of 3 years. If you've been unlawfully present in the United States for 1 year, then a 10-year bar is automatically imposed and makes you inadmissible for that period of time. And is there some law enforcement agency that keeps track of how many days? No, it just kind of happens magically by operation of laws, and that's in quotes, operation of law. And so when you apply, they're going to recognize and say, oh, okay, this is what's happened. You also need to be aware that there's a permanent bar if you've been present in the United States for more than a year and then you leave, or if you've just been deported or removed and then you re-enter unlawfully, then a permanent bar is imposed on you. Time bars, the 3-year and 10-year bar, are automatically waived for immediate relatives of U.S. citizens. So the people that this presentation, this video series, and the webpage that's linked to in the description of this video are about, the people who are adjusting status on the basis of their relationship to a U.S. citizen, you don't need to worry about the 3-year bar or the 10-year bar. So long as you have that lawful entry and you're an immediate relative, that's automatically waived. But permanent bars can be complicated. They are not automatically waived, and they typically require you to leave the country for a period of 10 years first and then reapply for something called consent for readmission to the United States. It's technically not a waiver, but you do have to apply for it, and you'll end up going through the consular process. There are ways to overcome the permanent bar to the U.S., but those are generally not related to this adjustment of status as an immediate relative process. All right. Moving on to criminal history bars, the most important thing I have to tell you is if you have a criminal history, you should talk to a lawyer. It's impossible to list all of the crimes that might make you inadmissible because the laws are different in all 50 states, and your specific circumstances surrounding any charges you might have are different in all 50 states. And then finally, you need to be aware that not all criminal histories can be overcome with a waiver. Criminal histories can be very difficult in the immigration context. And so if you have a criminal history, you should absolutely talk to a lawyer. It's really hard for me not to dive into extra details on this slide because it is an interesting area of the law and there are lots of little quirks, but the best advice I can give you in this video series anyway is to talk to a lawyer. Maybe when we post an in-depth guide to waivers and inadmissibility, that word again, we can talk more in depth about the issue. But the long and short of it is you should just talk to a lawyer if you have a criminal history. Okay, moving forward. A waiver, if possible, will likely center on what's known as a hardship analysis. There may be other means of getting a waiver, so if you read the form instructions, it might mention a couple of other ways that you can qualify for a waiver. But this video is going to focus on how you qualify for it through your immediate family relationship to a U.S. citizen. And so That's what we're talking about here. And the way that you do that is through a hardship analysis. You have to prove that if you were removed from the United States or not allowed to get a green card, that your family member, your U.S. citizen family member, would suffer extreme hardship. And so that's what you have to prove. You have to prove that it goes above and beyond normal hardship. Basically, the law recognizes that, yes, being deported or removed from the United States is very difficult for families, and they know that it generates a what they would call as normal hardship. And so you have to prove extreme hardship, which means you're going to suffer even more hardship than normal hardship in a deportation scenario. This isn't something that I particularly like about our immigration law and policy, but it is a practical reality. And so you have to get to extreme hardship. You have to show them that life will be very, very difficult. How do we prove that? How do we show that? What do we look at? And what do we present to USCIS when we file a waiver application? Well, typically the kinds of hardship that we look for when we sit down and we interview you, we talk to you about your emotional and mental health. We talk to you about any physical health issues. We talk to you about the financial well-being of the family if part of the income is suddenly absent from your family life because of a deportation. We talk about hardship related to conditions in the home country. For example, if the immigrant family member is removed to their country, do they run the risk of being harmed or persecuted in their home country? And then finally, we just discussed discretionary factors, which could include time in the U.S., whether or not you've paid taxes, whether or not you've worked lawfully, how many children do you share or have in the United States that are born here in the U.S., and a whole host of other factors could be positive discretionary factors. And so we like to interview our clients and really get an in-depth understanding of all of these aspects of their life, their emotional and mental health, physical health, and so on. To give you an example of the kinds of cases that we've won waivers for, or that are easier to win waivers for, is when you have the U.S. citizen family member is in a wheelchair or has some other disability or has been in an accident, a life-changing accident, and they really need that immigrant spouse to be with them, to help them out. Those are the kinds of scenarios where you can get an immigration waiver pretty simply, just based on that documentation. Weaker cases tend to be people who are newly married, who are young, who are healthy, and who don't have any children. Sometimes when I talk to those couples, I say, well, are you planning to have children? And if the answer is yes, they'll say, well, go have a baby and see me in 9 months, right? So, and I know that sounds a little facetious, a little odd, and yet it's going to be hard to prove extreme hardship without some additional factors if you're young, happy, and healthy and have no problems at all. And so one of the things we do as lawyers is we help bring out the details of your story. Now, I will tell you, just because you're recently married, young, happy, and healthy, doesn't mean that we still can't win a waiver. I've won waivers in situations where, for example, one or both of the people had been married before, and then they found this new relationship that is mentally healthy as opposed to what they come from, a difficult or dysfunctional home situation growing up, and now they've found love and stability in their immigrant spouse. And we've won cases like that as well. So proving extreme hardship can involve going to see a mental health professional, going to see a doctor to get a diagnosis of your physical health, and it can involve bringing taxes, pay stubs, those kinds of things. So there's a lot of evidence that you could look at on a waiver, and the goal of the attorney is to tell the best story possible that fits within these legal factors and convince the bureaucrat on the other side of this application, hey, this person really is going to experience extreme hardship. They're going to experience something far beyond what people normally experience. Okay? So waivers are fun to do from an attorney perspective, but they are time intensive, they're effort intensive, and they do require a legal expert to kind of get those nuts and bolts right. Okay? The biggest takeaway is if you have a criminal history or other grounds of inadmissibility, hire a lawyer. The process is complicated. It can vary from case to case. Waivers are expensive, so you need to make sure you know what you're paying for. I think by and large, immigration attorneys are a professional bunch, and we do good work. However, I have sometimes seen waiver applications that come to me, like if a client says, well, hey, I got my waiver denied, I'd like a second opinion. And I'll see we'll get a file release, and I'll see the application and see that the level of effort that our office puts into a waiver application wasn't done. And in fact, far below what I would consider to be acceptable. So Make sure you understand, like if they say, well, this is going to be $10,000, that better be a very good waiver. They should explain to you and take the time at that price point exactly what's going to go into your waiver application and what they're going to do. I'll tell you that we help you prepare a detailed affidavit for both parties. In the event of a spousal waiver, we'll get an affidavit from each spouse to explain why this would create hardship. We organize and bait stamp your evidence so that it's very well organized, easy to follow, easy for the bureaucrat on the other side to see in the documents alone, oh, this is why this is going to be more challenging than normal. And then finally, we always write a legal analysis that accompanies your application and your evidence packet. And so we think we go the extra mile to make sure that waiver applications are granted. Thank you for watching this video. One thing I want to make sure that you understand as you watched it is I mentioned a lot of times that you should hire a lawyer. And I want you to be aware that we're very transparent when it comes to these issues. We put a lot of content on our website, and we're generating a lot of content now on YouTube. And so if you want more information about waivers, please feel free to visit our website at Tingen.law. Look through our knowledge base with more than 500 plus legal information articles, and you can find more information about waivers. You could still technically file a waiver without the help of an attorney, but I don't think you're doing yourself any favors. Waivers can be complicated and difficult, even for trained attorneys to win. And so I think it's the right call for you in this situation. We do plan on providing additional content in the future about the waiver process in particular. And if we ever do a deep dive, I'll post that video here. So why don't you go ahead and like and subscribe this video, and that way you won't miss it if we do come out with additional information about inadmissibility and waivers in the future. Just so you're aware, this video is part of a series about adjustment of status for immediate relatives of U.S. citizens. And so the point of this video is in the context of that article that we have on our website, the link is in the video description, is to help people better understand, okay, so I am an immediate relative. I do have a lawful entry, but I've got some things that might cause some difficulty. And so that's what this video is aimed towards. If you want a deeper overview of inadmissibility and waivers in your context, my advice right now is to go see a lawyer or look up information on our website, or frankly, Google it yourself. That's totally fine. And I wish you the best of luck. But I also wish to see you here in my office. Give us a call. Look us up on YouTube, find us online. We'd be happy to help you with your waiver process, your green card process, whatever that may be. Best of luck to you, and thank you again for watching this video.